Morning everyone, and welcome to the 19th meeting of the Justice Committee. We have apologies this morning from Alistair Allen, MSP, who cannot be with us, and we are joined by Annabel Ewing, who I welcome to the meeting and who I invite straight away to declare any relevant interests. Annabel.
Thank you, Convener. I would just like to draw members' attention to my declaration in the Register of Interest, wherein they will note that I am a member of the Law Society of Scotland, that I hold a current practising certificate, albeit that I am not currently practising. Thank you.
Thank you, Annabel. Our first item of business is to agree to take item 6 in private. Are we all agreed? I don't see anybody disagreeing, so I'm going to take that as agreed. Thank you, and move to item 2, which is to consider an affirmative instrument, the Advice and Assistance by way of Representation Scotland Amendment Regulations 2020 in draft. And I refer members to paper 1, which is a note by the clerk on this SSI. And I welcome Ash Denham, Minister for Community Safety, and her officials, Kieran Burke and Joanne Tinto. Welcome, Minister, welcome, officials. And I invite the Minister to make a short statement on this instrument. And if any members want to then ask the Minister a question, could they please type in the chat box on Blue Jeans. Minister.
Good morning, Convener, and good morning to the committee. So these regulations will amend the Advice and Assistance by way of Representation Scotland Regulations of 2003 to provide that assistance by way of representation, that's shortened to ABWAR, can be made available without means testing in respect of persons seeking to appeal a decision of the Scottish Ministers to refuse an application to disregard conviction for historical sexual offence. The Historical Sexual Offences Pardons and Disregard Scotland Act was passed by the Scottish Parliament on the 6th of June 2018 and commenced in the latter part of 2019. And committee members will be aware that the purpose of this Act is to pardon persons convicted of certain historical sexual offences and to provide a process for convictions for those offences to be disregarded. So that information about that conviction held in records will no longer show up in a disclosure check. Relevant historical sexual offences relate to consensual sexual activity between men that was once criminalised but is no longer legal. And a disregard is sought in the first instance by way of an application to Scottish Ministers. In the event that an application is rejected, there is an opportunity of a review provided by appeal to Sheriff Court. Where an applicant wishes to be represented in court, such appeal. These regulations will provide that non-means tested ABWAR is available, subject to the Scottish Legal Aid Board being satisfied that the case has merit. And this will help to ensure that it is as straightforward as possible to apply for and to be granted legal representation in these cases, whilst at the same time mitigating it against cases without sufficient merit, proceeding on the basis of being wholly publicly funded. Thank you, Convener, and I'm happy to take any questions from the committee.
Thank you, Minister. That was very clear, very grateful. John Finney would like to ask a question, please. John Finney.
Thank you. Thank you, Convener. Good morning, Minister. Minister, I warmly welcome this. There's a historic wrong that is being righted here, and I welcome this addition. Are you able to say what's prompted this move by the Scottish Government? Very welcome move, and the extent of a problem that exists, if indeed there is a problem, or is this to preempt potential problems, please?
So the Scottish Government wants it to be as simple and as straightforward as possible for individuals who are wishing to progress applications seeking pardons and disregards for historical sexual offences. So the reason we're doing this is we don't want people to have to be subject to the normal tests, and that would be the financial eligibility test. So in this case, they will not be subject to that test. There are the two other tests, which I mentioned in my opening statement, but not the financial eligibility one. We want to make this as easy for people as possible.
Thank you, John. I'm taking it that you don't want to, no further questions?
If I may, Convener, I just so has it been a problem, Minister? What's prompted this? I say again, this is very welcome as a way of providing assistance to individuals who've been the subject of a historic wrong. Has there been a problem with this?
There hasn't yet. I can advise the committee that to date, 8 applications have been made for disregard, and 6 of those were approved. 1 didn't actually need to progress, as after a check there were no records of conviction anymore, and 1 is still pending, obviously due to coronavirus lockdown preventing access to documents. So we imagine it to be very little used. So that just gives you an example of how many have been processed so far. But this, we had to do this as part of the original Act. So the Act required us to have this, and it was developed along with stakeholders to make it, as I was saying before, easy and straightforward.
Okay, thank you, Minister. Thank you, Convener.
Thank you very much, Mr. Finney. No other member has indicated that they wish to ask the Minister any questions about this instrument, so I think we can now move to its formal consideration. The Delegated Powers and Law Reform Committee has considered and reported on the instrument and have no comments. So the motion will now be moved. The motion is number 22554, that the Justice Committee recommends that the Advice and Assistance by way of Representation in Scotland Amendment Regulations 2020 in drafts be approved. Minister, to move.
Moved, Convener.
Thank you. So the question is that motion 22554 in the name of Ash Denham be approved. Are we all agreed? We are agreed. I then invite the committee to agree to delegate to me the publication of a short factual report on our deliberations. Are members agreed? Members are agreed. Thank you very much. Thank you, Minister, and thank you to your officials too for joining us this morning. I hope all of our businesses conducted this expeditiously. I'm going to move now, colleagues, to agenda item 4, which is to continue our consideration at stage 1 of the Defamation and Malicious Publications Scotland Bill. And this morning we're going to have 2 panels of witnesses on this bill. The first panel is Duncan Hamilton from the Faculty of Advocates and John Paul Sheridan from the Law Society of Scotland. And I'd very warmly like to welcome Duncan Hamilton and John Paul Sheridan to our meeting this morning. I thank both witnesses for their written submissions, which are, as always, available on the committee's web pages. And I invite them to make a short opening statement, if they wish, before we will move to questions. So, Mr. Hamilton, would you like to begin?
Yes, good morning, Convener. As a former member of the committee, I know the greatest gift I can give you is brevity, so let me make only 2 points at this stage. The first is the general approach to the law in this area. The Faculty of Advocates obviously represents a body of practitioners, and we act both for media interests and for private individuals. I make that point simply to say that what I hope to bring to the committee today is the experience of practice both in defending freedom of expression and also, where necessary, in restricting it. Reading the evidence of last week, I think perhaps what may be helpful today is that balance to understand that there is no monopoly on the definition of public interest in relation to either side of that argument. Both have a legitimate role to play. The second point is simply a general point in relation to the approach that the faculty has taken to the bill. As a faculty, we start from the position of the existing rights and responsibilities that are there, and we simply invite the committee to remember that the onus is on the government to set out what is deficient about the current position and why what is proposed is going to improve the situation. And again, if there is one key word in all of this, it is balance. And some of the concerns and the issues that we'll go on to discuss, I think, arise from the sense from the faculty that some aspects of this require to have greater balance.
That's very helpful, Mr. Hamilton. Thank you very much. Could I ask John Paul Sheridan if he wants to make a short opening statement before we move to questions?
Yes, Convener, thank you. Just very briefly, very similar to Mr. what the society has done of this, and in relation to the written submissions, we convened a round table event for all the practitioners who specialise in defamation, both in the media and representing private individuals. And what we seek to bring to this debate is that balance between the private individuals and the media interests. We very much welcome this bill. It's a very important and useful bill. And in particular, the Society welcomes the fact that it will make the law of defamation much more accessible to public generally, whereas when it's codified in certain places, it's much more accessible than trying to go through some very ancient case law. But I have nothing really further to add at this stage.
That's very helpful start. Thank you both very much. We're going to move now to questions. And could I just say to members, please, if you have any supplementary question that you want to ask, could you just type R in the chat box on Blue Jeans? And could I ask every member, please, to address all of their questions to a particular witness, so the witnesses know who to speak first and broadcasting know who to go to first. And with those reminders, if I may open with Liam MacArthur, please. Liam.
Thanks, Convener. Having fallen foul of that, probably worse than anybody else last week, I take the reprimand in the spirit in which it's intended. Can I thank Mr Sheridan and Mr Hamilton for their opening comments and actually providing a perfect segue into the line of questioning I wanted to pursue. I mean, obviously last week we heard from those with principally a media interest, or from an academic perspective as well, and therefore the focus was very much on the chilling effect that is alleged to surround the current laws around defamation, that what I think they were looking for, and it seemed to be fairly positive, was a greater protection for the freedom of expression. But both of you have alluded to the balance that needs to be struck in this legislation. I think that is something the committee would recognise. So I would be interested in the perspective, maybe first from Mr Hamilton, on whether or not that balance has been achieved. You've intimated that you don't necessarily believe that balance has been achieved. So it'd be interesting to know where you see the imbalance having been struck in the way that the legislation is currently framed.
Yes, thank you. The important starting point in all of this is that we are dealing with a right to reputation and a right to freedom of expression, which are both qualified rights. It is accepted that neither one of them trumps the other. There's very clear case law on that. Therefore, it follows that there will always have to be a chiselling of those rights in different areas depending on the facts and circumstances of any given scenario. Now, in terms of this bill, there has been a very clear policy decision taken, which is, it seems to us, that the freedom of expression side of it is understandably promoted, and that's something that we support, but that when you look at the safeguards that are there as the checks and balances on that, those are diminished to a level that perhaps tilts the table too far. Now, if you look at any one of the issues would assist with that. Serious harm, we say, is too high a test. The position on single publication, we say, is a difficulty. We say that the 1 year limitation, again, too far on the side of freedom of expression. We say that the position in relation to secondary publishers, again, a difficulty. Now, that's not because the faculty is looking to be difficult about this. It's simply that as we look at this as lawyers who deal with it in practice, it's important to remember that we have individuals who come quite properly looking for a remedy from their courts. And part of the responsibility of Parliament, of the committee and of the faculty is to ensure that the balanced legislation recognises the rights of those individuals. Everybody is in favour of freedom of expression until they are defamed, at which point that person takes a different view. And when they come for a remedy, and when you come for a remedy, you need to know that the law that's been passed is one that is balanced.
That's helpful. I'll maybe invite Mr Sheridan in a second on this, but you talk about that balance in a sense going too far the other way. I mean, is it accepted that as things stand at present, that there is an imbalance in a sense towards the protections in relation to reputation, that works against that freedom of expression, that the chilling effect that was being referred to during last week's evidence, and therefore, in a sense, what you're arguing is maybe the pendulum perhaps needs to swing back towards freedom of expression, but your argument is that it's swung too far in that direction.
Well, instinctively, as somebody who's involved in media law, I'm somebody who promotes and defends the freedom of expression in the courts. I don't think, though, that what we're dealing with here, this was an opportunity to update the law, but it's not. I wouldn't assume from that the balance that was there was necessarily wrong. There is an ongoing and necessary tension between Article 8 and Article 10, between the right to a private remedy and general freedom of expression. The only question for a parliament is to try and create a legal framework within which those rights can be examined in the context of any individual case. So, to answer your question, do we start from the point of view of there needs to be necessarily a greater weight put on freedom of expression than was already there? Not necessarily, no, because the courts already were bound to look at freedom of expression, already do so day and daily, give substance to those rights. So really, if we're looking at refreshing and codifying some of this, we shouldn't start from the point of view that there is necessarily already an imbalance. And can I say one thing about the chilling effect? It's one of those catchy phrases. It is a real thing in certain circumstances. But what shouldn't happen is it shouldn't be adopted by those who simply want to say freedom of expression trumps everything, and that any attempt to restrict freedom of expression for whatever purpose is going to be necessarily a chilling effect. One man's chilling effect might be another person's opportunity to have a remedy as a private individual.
Now that's helpful. I mean, I think the witnesses last week, to give them their dues, evidenced the chilling effect as it applied and had been experienced in their particular spheres. But Mr. Sheridan, I'd be interested in your take on those questions, and in particular the point again that was being made last week about often the tactics that are deployed initially in the sending of letters as a shot across the bows in the hope of discouraging any publication that don't necessarily, in a sense, suggest that there is any defamation, but which are used as a means of, as I say, disincentivising anybody from publishing.
Yeah, well, I suppose the starting point here, you need to bear in mind what the defamation remedies are for. They're not about protecting assets or income, they're about protecting reputation. If you look at it in the context of reputational protection, a reputation can take a lifetime to build up, but can be lost very, very quickly. And in that context, when we're looking at balance, the society's position is that, in effect, the balance appears to be broadly right in the main just now, but there's clearly political decisions to be made, and the thrust of the bill is to give greater protection for publication, and that is a perfectly valid approach. The difficulty that the society thinks is that where one combines a number of factors together, it really shifts the balance in favour of the media organisations. Mr. Hamilton listed off 4 specific areas there, all of which tend to mitigate against days, so the serious harm test, just limitation period, the single publication rule, the secondary publishers, all of those are weighted in one favour rather than the other. And in relation to the chilling effect, there's clearly quite a lot of detail in Section 6 and 7 which defines the public interest and honest opinion. And in one view, those alone provide adequate protection against the chilling effect. Now, I do entirely appreciate there's the practical effect that some private individuals have access to greater assets and legal advice than others, but that's probably not something that can be dealt with in terms of this. That is more about providing equality of arms to individuals, and that's something that could be dealt with in other ways through legal aid or otherwise. but to a large extent, there is not a great deal that the bill itself will do in relation to that, because there will always be strong or wealthy individuals who want to get around.
Thanks for that. I can see Mr Hamilton wants back in. I was just going to ask, we're going to come on to the other issues, serious harm and secondary publishing and all the rest of it, but just in terms of the implications for the rights of privacy and protection of reputation, are you able to give us an indication as to what you believe the implications of this bill are for that? And I'll bring in Mr Sheridan first and then Mr Hamilton.
Well, as I say, the rights for privacy, for those four areas which I've just listed, in my view, that will limit an individual's ability protection of their reputation.
Mr Hamilton?
Yes, I mean, by definition, if there is a relaxation of the protections for somebody's ability to enforce a defence of their reputation, then that's a weakening of their position. I wonder if I might just go back, though, to the point that you made a moment ago, because I saw it raised last week about pre-litigation correspondence and letters, because, again, I think we need to be careful in this situation. First of all, pre-litigation correspondence and engagement in every area of law is actively encouraged. Why? Because it has the capacity to resolve matters without it going to court. Secondly, are we really saying that we've got to the stage where somebody is not able to instruct a solicitor to go and write a letter to defend their position or to put on notice somebody who they believe is defaming them, having taken legal advice on that? And thirdly, the idea that those receiving those letters are not capable of dealing with that letter without all of a sudden being put into a year-long state of fear and panic is simply not what happens. There is a regular stream of correspondence that goes backwards and forwards between solicitors and media entities. It is the very stuff of media litigation. So I did see there was even a suggestion that there should be some additional amendment to the bill which would have some impact on that pre-litigation position. I would strongly urge the committee to be very cautious about going into that territory.
Now, that's fair comment, Mr Hamilton. I don't think there was an expectation the committee may go down that route, but at the same time, I think a distinction would be made between larger scale media outlets who, as you say, deal with this as sort of custom and practice, but for others, the impact of those letters can be very different. But I'll leave it there, Convener. Thank you.
Thank you very much. Could I move to the question of whether the statute should define defamation, or whether defamation should, in the view of our witnesses, continue to be defined in common law by judges? And perhaps I can ask that question to Duncan Hamilton first.
Yes, Convener. I mean, our position is that there isn't really any difficulty at the moment in understanding exactly what is meant by defamation. The courts implement that on a daily basis. That said, if an act is being brought in for the purpose of putting it all in one place, we can understand why there's a desire to do that. However, as you'll be well aware, the difficulty of legislation sometimes is that it takes away a flexibility in all of these matters, and sometimes that flexibility can be a very useful thing. But on the specific question of whether the common law test is one that can be put into statute, it can. Does it improve matters? Not particularly. Does it detract? Not particularly.
Mr. Sheridan, do you agree?
Yes, broadly. The only point I would say, though, is go back to my opening remarks. It's about accessibility, and where it is quite clear from the statute to general members of the public what the law is specified in this. Easier follow and easier, more accessible purposes, but it doesn't change the test, and that there's no particular reason to do it beyond that.
Oh, okay, that's helpful. Thank you. And what about the actual definition that we find in Section 1 of the bill? Do you have any concerns, Mr. Sheridan, about the way in which defamation is to be defined in this legislation?
No, it really reflects the common law test, so the society's no difficulty.
Okay, thank you. Same question to Mr. Hamilton. I mean, there have been a number of concerns brought to the attention of the committee about some of the language that's used in the definition of defamation in Section 1, the reference to ordinary people, the fact that the requirement for opinion to be lowered in society generally appears to be removed. I know Rona Mackay wants to ask some questions in a minute about serious harm. So absent the serious harm element of the definition, Mr. Hamilton, do you have any concern about the way in which defamation is defined here?
I think all definitions are open to criticism. I take both of those points as being aspects that could be concerning. Equally, however, right-thinking members of society, which would be one part of the existing definition, would itself, if you're putting it into statute, presumably be something that would be open to criticism as well. I think the courts have adopted a range of different tests, all coming to broadly the same thing. So if we're looking at this in the context of how it works in practice, I've never encountered a position in court where the court has been unclear, or there has been a real dispute between parties about the existing definition of defamation. That being the case, staying as close to that as possible just logically makes a degree of sense.
That's really helpful, thank you. I'm going to bring in Rona Mackay now, and after Rona Mackay, it will be John Finney. Rona.
Thank you, Convener, and good morning, panel. Yes, I'd like to return to the issue of serious harm and the new threshold for that. You know that our witnesses last week were largely supportive of this, and if I could just go back to something Duncan Hamilton said, please, about the pre-litigation stage letters. Taking on board what you said, are you saying that none of them are vexatious or frivolous? And you sort of alluded to the fact it was common practice, but is that necessary in your view? And would this new threshold not have an impact on that, the less necessary ones?
Specifically in relation to the pre-litigation correspondence, I can't see why it would. First of all, I'm not aware of solicitors in this field sending vexatious letters for the purposes. That's not what solicitors tend to do. If it's perfectly true to say that somebody might send a letter on behalf of their client that doesn't ultimately reflect what a court would find, and that they seek to assert a position on behalf of their client, well, so be it. I mean, that's the nature of what solicitors are doing in their client's best interest, which is how they're bound to act. But is that itself going to change because of making a test in legislation about serious harm? No, because if that solicitor is going to send a letter for that purpose, it's going to send that letter anyway. The serious harm test only kicks in as a matter of law when it reaches a further stage. So, I mean, I don't really understand the pre-litigation point particularly, because it must be right that people have the opportunity to go and assert their right through their instructed solicitor, regardless of whatever test is adopted in statute.
Thank you. And if I could just, before I go on and to ask Mr. Sheridan the same question, if I could just ask you about the threshold and how you believe that could be demonstrated. What is the criteria for this threshold? And you've mentioned reputational damage, which is of course pretty obvious. Would it also be loss of earnings or any other type of factor? I mean, who would define it? Mr. Hamilton, can I ask you?
Oh, beg your pardon. Sorry, I thought you were waiting for Mr. Sheridan.
Okay, no, that's fine. I'll go on to Mr. Sheridan.
Who would? Sorry, would that be included? Yes. Well, you would include all of those things. But in terms of, sorry, do you mean in this pre-litigation correspondence still?
No. Moving on just to the serious harm threshold.
Oh, I'm sorry.
In terms of how would it be defined and who would take that judgment about whether it was reputational or otherwise?
Well, the court ultimately, I mean, what the Supreme Court has held is that there have to be two parts to it. There's the serious harm arising from the words, but then there has to be evidence of actual impact in relation to those based on actual factual material. And yes, that could be across a whole range of things, reputational and patrimonial loss. Yes, absolutely. Can I just say, though, before we move on to that aspect, there is an important part from the faculty's perspective about the whole concept of serious harm. And I think it's made in the written submission. Back in 1999, when the Parliament started, there was the phrase that you will remember, Scottish solutions to Scottish problems. That is not in our submission what we're dealing with here. What we're dealing with here in our submission is an English solution to an English problem. This was brought in on the back of various cases, Jameel Thornton, arising from a sense of unmeritorious or frivolous claims being brought forward, hence the need for a higher threshold. That, I can say to you, from a position of Scottish practice, is simply not the case. It's just, it would be the opposite of adopting a Scottish solution to a Scottish problem. And therefore, before we go any further with that and simply adopt it, I would stress that that is not, in my view, an appropriate fit.
Okay, thank you. That's interesting. Could I ask Mr. Sheridan questions along the same lines? Your view on the pre-litigation stage letters and also the threshold for the serious harm test?
Yeah, well, in terms of the pre-litigation correspondence, there's 2 points I want to make. Firstly, that I would agree with Mr. Hamilton in the sense that the serious harm test does not really come into correspondence between solicitors prior to any litigation. That's qualified though by my second point, which is it potentially comes in and becomes relevant if we get to a situation where a publisher or a journalist decides to make amends or makes an offer of amends, because we'll maybe come on to this later in terms of where an offer, one of the issues is if they're making an offer of amends, whether or not that of itself is an implicit acceptance that there was serious harm. And that would prevent that argument being taken in court if the offer of amends was not accepted. But the general point in pre-litigation correspondence, I just don't think the serious harm test at all. On the second point, the serious harm, what the test is, and again, it's been what the wording here has been taken, Mr. Hamilton's direct, has been taken directly from the 2013 English Defamation Act. And that went to the Supreme Court relatively recently, which has held that there has to be, as a matter of fact, evidence about the reputational loss or serious harm to either reputation or financial position. Now, again, that was effectively designed in England because there was suggestions of libel tourism and that proceedings were being raised without merit in English courts. And again, I would echo what Mr. Hamilton says, that there is no evidence to support that as being an issue in Scotland. The legislation and the statutory test, or the test of serious harm, has now been in place in England for a number of years, and there has not been any uptick in Scottish defamation proceedings in that period of time. But there's probably a number of reasons for that, not least the fact that our courts tend to be a bit less generous in any awards of compensation. But again, this is a specific problem in the English libel courts, where, as far as the Law Society is concerned, and it sounds to me that the faculty advocates agree that there is just not that problem here at all.
Okay, thank you. So, I mean, from what you've said and from what Mr. Hamilton said, I mean, is there really a need for this legislation? I mean, does defamation, the Defamation Act, need refining?
I think again, going back to my point at the start, I think it's useful that there's a codification of certain aspects of it, and there's an accessibility point. I think the wider problem with defamation, which this bill probably doesn't really address, is the whole internet publication, and this deals with it to a limited extent in the sense of retweeting.
We're coming on to that, Mr. Sheridan. Yeah, we'll be coming on to that. Yeah. Okay.
Yeah. But I mean, I think certainly I think the Society is in favour of this bill, but just queries certain aspects of it, whether or not they get the balance right. And the serious harm test, in our position, is that takes the balance a little bit too far.
Okay, thank you. Thank you.
Thank you very much. Okay, Liam MacArthur wants a brief supplementary on this, and then after Liam, it'll be John Finney.
Thanks, Convener. Yeah, just picking up the points both Mr Sheridan and Mr Hamilton have made. Mr Hamilton, you referred to a sort of an English solution to an English problem. Obviously, this bill emerges from work carried out by the Scottish Law Commission. So is it your view that the Scottish Law Commission have misunderstood the issues that need to be addressed here, or does the bill deviate from what the Commission came up with as part of its deliberations?
No, do remember that the Scottish Law Commission itself drew heavily on the 2013 Act. So the history of this goes back to 2013 when that's brought in England. The Scottish Government at that time decided not to follow that path at that point, and therefore there was created a gap, which the Scottish Law Commission then quite properly decided to fill and to examine this. The Scottish Law Commission then looked very closely at the 2013 position, and there was a fork in the road choice, I suppose. One argument, which was a point I made to the Scottish Law Commission at the time, and one argument was to say that in Scotland we don't have a sufficient number of defamation cases for the proper healthy development of jurisprudence, and that's a thing that if you were to compare us with, for example, Ireland, which is a booming defamation practice, well, you know, so it's nothing about size is the point there. So you can either develop a system that is healthy in that regard, or we can simply accept that Scotland has so few defamation cases that really what should happen is that we kind of take a slightly off the peg position from England. Now, there is an argument that if Scotland does not follow aspects of the English legislation because of the absence of cases in Scotland, that Scotland will sort of end up out of kilter, and there will be difficulties that will arise from that. That's a perfectly legitimate position to take. I just want that to be a very clear choice that people are making with their eyes open, because what we can't do in my submission is simply accept that because it's in the 2013 Act and others have looked at it in that context, that it's appropriate in this context. And our clear position is that the serious harm test is inappropriate, and we know it's inappropriate because it arises out of circumstances that are simply not present in Scotland. We don't have too many cases, we have too few.
Okay, thank you. I think that point's been thoroughly made. Thank you very much. John Finney, please.
Thank you very much indeed, Convener. I'll go first to Mr Sheridan with a question, and it's about the Derbyshire principle, which is presently recognised in Scots law, and the bill creates a version of that, which includes specifically preventing public authorities and councils that hold a majority of shares, appoint a majority of members, or otherwise exercise significant control. So that would cover ALIOs. The bill, however, would create an exemption for businesses or charities which only deliver public services from time to time. Now, we know the landscape of public services has altered considerably over the years, including, for instance, private prisons. There seems, as with other aspects of the bill, to be in the media, if we call them correspondence, illegal correspondence, media correspondents are concerned that this would prevent proper public scrutiny, and because of the different way local authorities configure their workloads, a postcode lottery, undermining the Derbyshire principle, and legal respondents state that the implications of Section 2 are not clear, gone much wider than currently, and may prevent, for instance, housing associations, universities, and others who do public functions such as lawyers and nurses from raising actions. I wonder, could I get, first of all, Mr Sheridan and then Mr Hamilton's opinion on the provisions in the bill around the Derbyshire principle?
Well, I suppose, first of all, we're very much in favour of the retention of the Derbyshire principle, but I think that the problem that we've identified, and is set in a bit more detail in the written submissions, is about the drafting and how this is extended. I mean, if you look at the matter of principle in Derbyshire, broadly speaking, the reason that public authorities weren't able to raise defamation proceedings was because ultimately public scrutiny of public decisions was to be encouraged, and effectively the decisions should be made about that should be at the ballot box rather than the courts in terms of defamation. So that's broadly where it is there. The difficulty, though, which arises now is because of the multifarious nature of the way that public services are delivered. And you could get an anomalous situation where there's a private body carrying out public functions, whether it would be prisons or housing the homeless or whatever they are, that in one aspect of that company are able to protect their reputation with defamation proceedings, and in another aspect of that company performing different functions, they're unable to do that. Where we particularly have a problem with society is to what is the definition as to what is and isn't supposed to be covered. Universities, housing associations, even individual civil servants or nurses who are employed. The way the wording is set out in the legislation just appears to be potentially very oddly drafted. I'm not sure that there's a very good solution for that, but I think certainly that drafting needs substantially tightened up.
Of course, ironically, we may well look to the likes of yourself and the society to provide alternative wording. So maybe time to reflect on that.
Yeah, I mean, we have given some quite detailed written comments in the written submissions about that in the various sections which we think need amended.
I wonder, Mr. Hamilton, do you have comments, please? Thank you, Mr.
Yes, thank you. I agree with pretty much everything that Mr. Sheridan has said, and with the particular point that you've raised, which is the question of from time to time. If a wholly private company is not a public authority because it carries it out from time to time under Section 2.3, presumably if it does it for more than from time to time, it would be COD, which then does create this potential anomaly of a private company being able to raise proceedings in relation to work in the private sector but not in the public sector. We again absolutely accept and embrace the fact that the principle should be enshrined, but I think there is an issue around the definitional sections there which needs to be looked at. Can I also say in relation to the earlier part, so that's about non-natural persons, and all of the points that you've made about that I think are right. There's also the question about, presumably by definition, natural persons. So in Section 2.2, for example, the functions of a public nature is the phrase that then creates some degree of question mark. One of the people on the panel, the faculty who looked at it, raised the question of general practitioners. What does a GP do in that position? Are we dealing with someone who includes functions of a public nature? There is then in Section 2.5. It says, for the avoidance of doubt, nothing in this section prevents an individual from bringing defamation proceedings in a personal capacity as distinct from the individual acting in the capacity of an office holder. Again, not necessarily clarifying, I know what it's trying to do, but I'm not sure that taking it all together, we're left very clear. And to Mr. Sheridan's earlier point, which is a very good point, which is that part of this exercise is to make this accessible and clear and understood. I have to say, looking at that section, I don't think anyone would look at that section and say, aha, I now understand what you mean.
Okay, that's very helpful. Thank you both very much. Thank you, Convener.
Thank you. I want to come back on that in a minute, but I'm going to bring Annabel Ewing in first. Annabel, please.
Thank you, Convener. On a not unrelated subject in terms of eligibility to raise an action, I understand last week it was suggested by PEN, and it has been suggested by media respondents, that the right of a business to sue should be limited to businesses with fewer than 10 employees. And I understand that this call has been motivated by what people term an equality of arms. And it would be interesting to hear first from Duncan Hamilton and then from John Paul Sheridan their views on that in terms of the principle and in terms of the threshold being proposed to carve out. Thank you.
We can't support that. We don't really understand it. There is no position in principle that supports it. There's nothing magic about the number 10 or 20 or 30. If a company has the right to raise proceedings as a matter of legal principle, we see no basis whatsoever for the suggestion of 10 employees. So I'm afraid, beyond simply saying I can't give you a legal principle behind that, because I don't think there is one.
Thank you. And Mr Sheridan?
Yeah, I have nothing to add really. I agree entirely. In terms of equality of arms, I mean, some of the media organisations who would potentially be recipients would have at least the same financial clout behind them as any business would. So I don't even think the equality of arms, and certainly nothing from point of principle, would support that.
Thank you for those unequivocal responses. I understand that, in fact, those who are proposing such an approach cite what they term to be the Australian model, which they suggest is exactly that the right to sue is excluded for businesses with 10 or more employees. Is this something that either of you are aware of, Duncan Hamilton and then Mr Sheridan?
I have to say, not before I read the suggestion. Again, there's also, I think, a slight confusion about equality of arms. Lots of parties go to court starting from a position not being equal in resources. That's why other things come in to try and level the playing field, whether it's legal aid or anything else, to try and ensure that there is equality of arms. So I think unless we're going to get to a position where we say that categories of people in a whole range of areas of civil law are not to be allowed to raise actions because they're just too big and too successful, I don't really see where this takes us. I think, with the greatest respect, it is a total red herring.
Yeah, sure. Nothing further to add. Nothing further to add.
Okay,
thank you, Convener.
Thank you very much, Annabelle. Can I just go back to this question of the so-called Derbyshire Principle and Section 2 of the bill, which the panel was exploring a few minutes ago with John Finney. I very much hear the force of the point being made that Section 2 is perhaps not the most elegantly drafted section of the bill. It raises as many questions perhaps as it answers in terms of how broadly the scope of the Derbyshire Principle is drawn. Now, I wonder if Mr Hamilton can help me with this. I wonder if we think that Section 2 isn't very elegantly drafted, we can think about ways in which we can change that draft. And we might want to expand the scope of the Derbyshire Principle, or we might want to constrict it. And we might want to move in either of those directions, depending on what we think it's trying to do. So what's the legal principle that underpins the rule in Derbyshire that public authorities may not sue in defamation? Is it that elected office holders should expect their reputation to be assessed in the ballot box and not in the defamation courts? Or is it that we want to somehow protect those who deliver public services, however it is that they do it, from the risk of litigation for defamation? If we take the former view as the underlying principle behind Derbyshire, we might want to constrict its reputation, its scope and its definition. If we take the latter view, we might want a much more expansive definition and sense of the Derbyshire Principle. Mr Hamilton, I wonder what you think about that.
I would instinctively have gone to the former, simply on the basis that the judgment was one which was really trying to draw a distinction between the appropriate accountability, if you like, the mechanism for that. And it was part of the principle that there was a freedom to criticise a public body in the exercise of its public functions, which is what creates the problem here. Because if it's right that I can criticise a public body in the exercise of its public functions, and those public functions are now to be outsourced to a private entity, I must be surely allowed to criticise that private body carrying out those public functions. If that is correct, the idea that the private body would not have the right to respond to that, whilst the same private body could raise an action in relation to a private contract, whichever side of that you want to come down on, there's a perfectly legitimate argument for both. But I think what we would say is that is a fundamental inconsistency that has to be addressed, whichever way you fall on it.
Mr Sheridan, anything to add to that?
No, not really. I mean, it goes. My understanding of the decision of the Derby Principle was certainly very much of the former, when it's all about the accountability of elected representatives in the ballot box. The delivery of services is a different aspect, because if you think about it from the point of view that elected representatives have always been able to sue for defamation in relation to allegations about their private life or anything else, and that would, I think that would be logically consistent with the approach taken from Mr. Hamilton suggested.
That's very helpful. Thank you both very much. Rona Mackay, please.
I'd like to go back to the subject of secondary publishers, Mr. Sheridan, which you touched on earlier. The bill would prevent legal proceedings for defamation being raised against someone who was not the author, editor or commercial publisher of the material, and it would create immunity for other parties who make defamatory material available, in particular internet intermediaries. I know you, Mr. Sheridan, believe there are risks to this approach to the internet, which is of course a current and your view of this, and is it only with regard to the internet that you have concerns about this part of the Act, part of the bill?
To the internet, because just the way newspapers in the past would be passed around is very, very different from the way that news stories can be passed around the world now. It's partly a combination of looking at secondary publications in connection with some of the other provisions which are proposed. If secondary publications, you could have a situation, for example, if someone with no assets at all was effectively put up to publish a story, and then somebody became the secondary publisher, who was a substantial media organisation but was able to avoid any liability because they're simply repeating or forwarding something that someone else had done. I think they could potentially lead to injustice there.
Okay, and I mean, is there some sort of solution that you think would be preferable to sort of, if you like, police the internet? And I know that's not a phrase that people would like, but you know, there obviously is an area of concern. Do you think there should be a separate, an entirely separate sort of process for internet or intermediaries?
Yeah, I mean, I think if you look back at what the Scottish Law Commission said, was that there was a much wider internet regulatory position being looked at across the UK. I still think that needs to be done. I think to some extent the secondary publication here in isolation without dealing with the principal problem first is a little bit cart before the horse.
Yeah. Okay, thank you. Can I ask Mr. Hamilton your views, please?
Yes, secondary publication may be helpful to the committee to understand a practical real-life example of how this might operate. Very often, if you have an individual who had put up something that is defamatory, you don't often know who that person is, and very difficult sometimes to get the identity of the individual. If it is then published again by someone, for example, an internet provider who is then someone that you can contact, you can bring it to their attention. So quite often what you would do is you would, using Section 1 of the 1996 Act, there's a defence there which allows a defence for somebody if they say that I couldn't reasonably, broadly speaking, reasonably be aware of the fact that this was a defamatory statement, then that would provide a defence. But by fixing them with knowledge that they are publishing that defamatory content, it then puts them in the position where action has got to be taken. Because bear in mind, what people are after here is a remedy, most times not for money, not for a court action, but simply to get taken down something that is defamatory about them. So therefore, by fixing that entity with knowledge, you can do something about it. Now, this bill, it repeals Section 1 of the 1996 Act. And on top of that, in the English Act, 2013 Act, Section 5 of the 2013 Act, directly deals with the operators of websites in a way that's not carried across into the Scottish legislation. So in England, you even after the 2013 Act, you've still got Section 1, and you've got a body of case law, Tammuz, and so on, which allows you to say that after notification, you have a problem as an internet, as a website operator. That is not going to be a position in Scotland, and that we say is a difficulty, because again, it just tilts the table too far. Where is my remedy? What is my possible remedy as a private individual trying to address the wild ramblings of a keyboard warrior? What do you want me to do with that? So So we have a difficulty with that, and I would say also that the evidence that you were given, which was that there was some kind of protection under Section 3.3, which was the sort of nodded in the direction of limiting the exemption, is nothing as to the protection that's there at the moment. So it is a very minor aspect, and I would contrast the position under Section 5 of the 2013 Act with where we are in this bill. It is right to say that the view was taken this is going to be looked at on a UK-wide basis. The difficulty with that is the whole purpose of this bill was to put in one place something that was publicly accessible and clear to understand, and yet the single greatest medium that we all use is missing from the bill. And the existing protections that are there in the meantime are being removed. So query, is that going to lead to a fair and a sound system?
Okay, so can I just ask you as a generic point, I mean, is it going to be an enormous task to get the balance right in this bill in terms of freedom of expression and, you know, a sensible way for people to access justice?
I think it needs, personally, and as a faculty, we think it needs quite a lot more work if you're going to find that right balance. Now, I should say, of course, that there comes a point that this is obviously a matter for the committee and a matter for Parliament. If the Scottish Parliament decides that it is unhappy with the current balance and that it wants to create a regime that is very heavily skewed toward freedom of expression and to remove existing rights for private citizens, that is a choice that the Parliament's entitled to make. Our concern as a faculty is simply that if the Parliament chooses to do so, it does so with its eyes wide open to what it's doing, because I think it is a fairly fundamental change, what is a very delicate balance.
Thank you. Thank you both.
Thank you. James Kelly, please. And then after James Kelly, it will be Liam Kerr. James.
Thank you, Convener, and good morning, panel. I'm going to turn to the area of defences, and if I can ask Mr Hamilton first, followed by Mr Sheridan. In terms of the bill, it sets out some areas of legitimate defence in terms of truth, publishing in the public interest and honest opinion. Can I ask what you think in terms of these definitions and whether you think there's sufficient clarity around them in the bill?
Okay, good morning. Let me take that first. The three, so veritas, truth, fine basically, although I would simply make the point that nobody really is unclear at the moment, but no harm in codifying it if that's to happen. Of more problematic would be honest opinion, which I'll come back to. The question of defence in a matter of public interest, which is essentially the replacement for the Reynolds defence. Again, I would stress what I think, and here I would agree with the evidence of last week, the Reynolds criteria have been extremely useful in practice for journalists and for lawyers to be able to say, here are a range of criteria. Does it constitute responsible journalism? Have you looked at the origin of this? Have you given a right to reply? And so on and so forth. Where we are now is in something which is obviously doesn't include those criteria. And the question, I suppose, that would have to be asked and only answered in court is the degree to which the Reynolds criteria will continue to inform the decisions of the court in relation to that new defence that replaces it. That's an unknown, but I simply note that that moving away from Reynolds may have some a diminution in terms of the clarity that comes around that, strangely, which is the opposite to what's trying to be achieved. In terms of the honest opinion, placing fair comment, I have to say the biggest difficulty here is the justification that's given for the removal of the public interest aspect of the existing fair comment defence. It is easily and regularly applied by the courts. And I was struck last night when I looked at this. If you look at the way, you probably don't have it in front of you, and hopefully your night was more exciting than mine, but paragraphs 99 and 100 of the policy memorandum, perhaps I can just read those very briefly. The justification for the removal of the public interest is the technical complexity of applying the defence means it's less effective and less frequently invoked than it may otherwise be in protecting freedom of expression. Simply don't accept that to be my experience and the experience of those in the faculty. The shortage of modern Scottish case law adds to the difficulties. At the same time as placing the common law defence in statute, the opportunities were taken to reform it. And it says the new defence It has no requirement for public interest for several reasons. First, the concept has not played a significant role in practice for many years, owing to the scope of the notion of public interest having been greatly expanded. That's simply not correct, in my experience. Secondly, a person should be equally free to make a comment on a private matter as on a public one. Well, that's interesting. There's a really big argument to be had around that, but I wouldn't simply assert it. And thirdly, abolition of the requirement on the public interest would simplify the defence and make it more straightforward to apply in practice, because parties would no longer have to contend with the uncertainty arising from the imprecise boundaries of the concept of public interest. First of all, I don't detect any difficulty in terms of giving legal advice or the courts applying it to the definition of public interest. And secondly, you will note that public interest itself is part of the previous defence. So this legislation itself it relies on the concept of public interest in a different context, in which case, why does that argument stand any scrutiny? So we have a difficulty on that one with the removal of public interest. And it may be just of interest to note that I think it's section 6.5, which includes, in terms of the opinion aspect, and section 6.5 includes public interest as being one that applying the public interest defence applying to comment as much as it does to fact, which then leaves a question as to what it is exactly that's being achieved by the removal of public interest. Sorry, that's maybe too much information at one go, but the bottom line is we're not convinced by the justification for the removal of public interest.
Well, that was comprehensive and helpful. Mr. Sheridan?
Well, given Mr. Hamilton's comprehensive answer, I've nothing to add.
Okay, thanks a lot for that. Just moving on to the area of compensation, where parties agree to allow a compensation figure to be settled. The approach set out in the bill is different to what happens currently, where there's an opportunity for the defence to offer to make amends, and that's taken into account in calculating the compensation figure. Can I ask again, we'll go in a different order, can I ask Mr. Sheridan, followed by Mr. Hamilton, whether you think the approach adopted in the bill is a fair one, or if you have any concerns about the offer to make amends process not being recorded to the same degree?
I think there is a concern in relation to that, because I suppose the assumption here is that most cases don't go to court, and that's very much to be encouraged to be resolved outside of the court. And at present, where a publisher or media organisation makes an offer to amends which isn't accepted for one reason or another, then there's a discount applied. There's no provision here for a discount, and I think what that would do would to discourage out-of-court settlements or offers being made out of court, which I think is inequitable in the sense that where someone makes an offer currently and they're entitled to that discount. If that were not replicated again, I think it would be problematic.
Thank you. Mr. Hamilton?
Absolutely. The offer of amends procedure usually amounts to something like maybe between 20 and up to 30–40% of a discount on the damages, precisely because we've avoided that position. As I understand, I'm not sure that the court is not empowered. It may still have the flexibility to apply that, given that it's looking at the whole circumstances as I read the bill. If there's any confusion about that, then it should certainly fall, if amendment is required in relation to that, to make it clear that the court is entitled to apply that discount, then it should. There is no good reason, and in fact it would defeat in many ways the whole point of the offer of amends procedure. So I have to say I'm not entirely sure that is not something that the court couldn't already do under the existing bill, but if the committee is concerned about it, it should perhaps seek clarity from the government.
Okay, thanks a lot. We'll certainly do that. Thank you.
Thank you, James. Moving straight on to Liam Kerr now, please.
Thank you, Convener. Good morning, panel. I would like to move on to malicious publication, please. So section 21 onwards. It has been argued, I have two questions for the panel. It's been argued that as drafted, there is a danger that businesses can bypass the protections on freedom of expression in the defamation because, for example, there is no requirement to demonstrate serious harm in the malicious publication sections. So the question I had before this evidence section was along the lines of, should there be? But perhaps having listened, particularly to Duncan Hamilton earlier, I wonder if the answer is no. And Duncan Hamilton, do you think that the serious harm test should be taken out altogether?
Yes, and the answer that we would propose is exactly that. I think the second option that you give is the way to achieve consistency. We don't support the serious harm test in either context. So that is, I suppose, would be my very short answer to that, and a very clear answer, I hope.
It is short and very clear. John Paul Sheridan, do you have any other answer to that?
No, I agree with that. Just to say that if this serious harm test was going to be enforced in relation to the defamation provisions, that it would appear to be logical to apply it into the malicious publications test. But again, like Mr. Hamilton, we think that it shouldn't have a feature in either test.
That's interesting. Thank you. Moving on then. So again, John Paul Sheridan, you particularly mentioned drafting earlier on, and I'd like to explore an element of that. Looking at section 21, the pursuer must show that the publication is false and that the defender has made a false and malicious statement. But under section 21(2)(b), a statement is malicious. There's a definition of what it means to be malicious, and it gives two possibilities. Either, number one, that the defender knew that the imputation was false or was indifferent as to the truth of the imputation, or that the defender's publication of the statement was motivated by malicious intention, and so on. So, does that drafting suggest that a pursuer could win in a case of malicious publication simply by showing that the defender was indifferent to the truth of the statement they made, i.e. there might not be a requirement to show malice, as I think there is presently, and if that's right, isn't that a significant lowering of the current threshold?
Well, I mean, the drafting might not be brilliantly done, but I think if you look at it in the context of 1A, where there's specific reference to being malicious, I think the intention is that it should be malicious. But if your interpretation of B1 is correct, then yeah, that would potentially lower the threshold, and that's particularly problematic given the difference in the burden of proof in malicious publications rather than defamation, where obviously if you can prove that it's false and made maliciously, then effectively the burden doesn't shift. So it potentially would have that impact.
Thank you for that. Duncan Hamilton, any further comment on that?
Yes, ultimately, I think the important point here is that indifference to the truth is already, it's the case of Horrocks and Lowe, indifference to the truth is in itself one part of the question of malice already. So to your question of would that alter it? No, it wouldn't. That is essentially already part of the equation. If I say something when I'm willfully reckless as to whether it's true or not, that can be a basis for malice. So in terms of why that's included in there, it will be for that purpose and arising from that body of law. So I don't think it will change the legal position.
That's very helpful. Thank you, Convener. I have no further questions.
Thank you, Liam. Moving straight on to Fulton McGregor next, please. Fulton.
Thank you, Convener, and good morning, panel. I was wanting to turn to section 30 of the bill, which, as you know, would enable a court to order a third party to remove contentious material as an interim measure before a final decision about whether it's defamatory or not has actually been reached. Now, last week, when we first started taking evidence, we heard some concerns about this. Do you share those concerns? And if you do you have any alternatives that might work? I'll come to Mr. Hamilton first, if that's okay.
Yes, thank you. I don't remember the specific concerns, but I do have concerns, and they are related to what I've already said. In terms of looking for an immediate remedy, there is already, through the pre-litigation process, an opportunity to do that. There's already reliance on established case law that says that if I notify you of something and you don't do anything about it, then you can become liable. And there is reference to Section 1 of the 96 Act, and there is also in the English provision Section 5, which does not read across. All of the things I've said about that previously are arguably the way to approach this. The difficulty is that what is proposed is under Section 30 that you have to apply to the court to take that down. So that actually makes it more expensive, more onerous, arguably, than having some form of either informal or regulated takedown procedure. Now, as a matter of practice, because most of the companies that people are dealing with are not in Scotland and are more used to dealing with English solicitors, it tends to be that there is actually quite a reasonable chance of matters being taken down. But in terms of what's going into this bill, if that is the protection, first of all, it is not sufficient in our view, and secondly, it seems to be a very onerous, expensive way of achieving that. And if we are talking, the government at various points relies on an argument of uniformity, and yet in other areas is not applying that. This would seem to me to be one where they should apply it.
Okay, thanks for that.
Mr. Sheridan, do you have anything you want to add on that question from Fulton McGuire?
Nothing that I really want to add, other than to say that it's obviously not mandatory to go to the court to do that, so there would be nothing in principle to stop takedown provisions being dealt with separately.
Okay, that's very helpful. Thanks. Shona Robertson, then, please. I think Shona Robertson wants to ask about a proposal that Scottish Pen put forward to the committee last week. Shona.
Good morning, panel. Yes, you probably are aware of the evidence given last week. You've referred to it earlier, where Scottish Pen put forward proposals for a new court action to provide protection from unjustified threats of defamation action. Do you have any views on this, in particular, if it was to be adopted, how it would operate in practice?
I'm sorry, are you asking me, or are you asking Mr. Sheridan?
Both of you, please.
Well, let me go first in that case. I think, no, that's not a proposal that we support. I haven't seen the detail of the proposal, but again, we are really in danger of traversing into substantive rights people in terms of defending their own reputation. I'm not sure what the threshold for that would be. I'm not sure what I'm not sure how it sits with their professional responsibilities. I think I'd need to see a lot more about it before giving you a full critique of it. But I have to say, in principle, it sounds like not an idea that has a great deal of merit.
Similarly, I think from the society's point of view, people should be free to enter into pre-litigation correspondence and write about protection of reputation without any fear that that letter itself should potentially give rise to a claim. Again, I would just I'd agree with the faculty submission in terms of that.
Okay, thank you for that. I mean, if you do have any further detail you want to submit, you could perhaps follow that up in writing to the committee. But thank you, that's helpful.
Okay, thank you. I've just got two final technical questions just to get your views on the record, if I may. One, which I think has been touched on, but I just want to make sure I fully understood your views about the reduction in the bill of the limitation period for defamation actions from 3 years to 1. And the second, an area of the bill I don't think we have touched on at all, which is Section 19 of the bill, which places significant restrictions on the court's jurisdiction in Scotland to hear defamation claims. So questions of limitation and jurisdiction, quite technical, but nonetheless we want your views, if we may, on the record on both of those issues. Mr. Sheridan first, please, and then Mr. Hamilton.
Maybe I can deal with the first, and maybe Mr. Hamilton will deal with the second. In terms of limitation, we don't see any basis to reduce the period of time. I know that there's the protection set out in the legislation or the bill, which would allow the courts effectively to extend the period of time. The difficulty with that is a practical one, where someone would need to raise a speculative action to know whether or not the court would allow it to be heard out of time, which I think defeats the purpose of the whole certainty of it. So I think from that point of view, we would be reluctant to support any shortening of the period of time in relation to raising of proceedings. In terms of jurisdiction more generally, again, Mr. Hamilton can maybe comment about more detail because he's mentioned this already, but one of the problems with Scottish defamation law is the lack of cases rather than having too many, and any attempts to restrict the jurisdiction would mean even less cases, which would not be good for jurisprudence, but also not be good for the sort of centre of excellence which Edinburgh is trying to promote itself as in a number of litigation areas.
Okay, thank you, Mr. Hamilton.
So yes, although technical, particularly the question of 1 year as opposed to 3 years is actually a very important point, because it touches really on a very substantial right. First of all, we are against that. We see no reason to move from 3 years to 1 year. That there is no particular justification given in relation to that. I and anyone in this field will have experience of a range of cases whereby things are not resolved within a year. Many cases, perhaps most cases, are raised within a year, but many are not. And one obvious example might be, a particular individual defaming somebody over a period of years, and eventually there's a straw that breaks the camel's back, and someone decides to proceed. Are we really saying that if that happens over a 3 year period, that the previous incidents are not matters on which an action could also be raised? There are a range of reasons in anybody's life or circumstance why things do not necessarily happen within a year, and therefore it is very much the onus is on the government to tell us why the current right of someone, which is 3 years, has to be restricted to 1 year. And what is the argument for that? So far, there was a question of cross-border litigation. There is absolutely no evidence of that. And I think even last week, there was no suggestion that there really was any attempt to come across the border. Secondly, even if that were the case, I'm not entirely sure why it is that we uniquely as a country are so terrified about having litigation. Most countries around the world are looking for ways to drive economic growth. And if we are an appropriate place to litigate, then why is that a difficulty? You don't find people in Dublin or in Dubai saying, don't come here to mediate, don't come here for arbitration. So I generally am slightly perplexed by that. Secondly, there was an argument that it has a chilling effect. Again, I do struggle with that. The idea that after a year, the newsroom is on tenterhooks to know whether they're going to be sued or not, I'm not sure about. And the third point was that the court, don't worry, because the court can always exercise its discretion to give you more than a year, for the reason that Mr. Sheridan quite rightly gives. That cannot be a basis if we're putting legislation together to remove the legal certainty. There is the case for moving from 3 years to 1 year in our submission simply isn't made. And it's an important point because, allied to all the other restrictions, it just adds to this sense of the table being tilted. In terms, very briefly, of the jurisdiction, for the reasons outlined, we would not support anything that made it more difficult to litigate in Scotland. It is already the case that the court will look at where the most appropriate forum is under reference to various of the regulations that you, Professor, will be very well aware of. And that is the position that should maintain. Any change to that to restrict the position in Scotland, in our view, is not justified.
Okay, that's very helpful. Thank you. We've got a brief final supplementary from Liam Kerr.
Yes, very briefly, Convener, if I may. Duncan Hamilton, just on that last point you made, which I find persuasive, but if we were to go to 1 year, as a limitation period is one solution to effectively to the issues that you've raised, to have some kind of continuing act limitation such that things don't age out if they're part of some kind of continuing act and or some kind of state of knowledge akin to a personal injury claim? Or is that just over-engineering the thing and we really shouldn't be putting a 1-year limitation in your view?
Let's rather than fixing a problem that we're creating for ourselves, let's try and avoid creating the problem in the first place. Ultimately, you could get into those types of arguments. They would be open. Nevertheless, why should a litigant be put in that position of uncertainty when seeking to go to their court to seek a remedy for what they consider to be a legal wrong? I don't know how it is that we've managed to put ourselves in the position of having to justify why that's a good thing. Now, of course, we're back again. This sounds terribly much like what I'm doing is banging the drum only in one direction. I absolutely embrace, support, and argue for the freedom of expression. I just think in each of these matters, when you go into them in detail, taken individually and collectively, the question for the committee at this stage, certainly in terms of general principles, is the balance right? And I think what I would urge upon you, for all the reasons given, is that the balance is not yet right.
Okay, thank you very much. Could I thank both Mr. Sheridan and Mr. Hamilton for a really useful hour of evidence? You've been very generous with your time with the committee, and I'm very grateful to you. We will suspend now for 5 minutes before hearing from our second panel, so we'll be back at 11:26. Thank you. Okay, welcome back, everyone. In fact, we're now moving on to our second panel of witnesses today on the defamation bill. And I'd like to welcome to the committee my colleagues at the University of Glasgow Law School, Stephen Bogle and Bobby Lindsay. And I should say that, of course, I am a member of the law school at the University of Glasgow, but Drs. Bogle and Lindsay are representing their own views and not any kind of collective view of the law school. And I have never discussed any aspect of the law of defamation with either of them before, although I look forward to doing so this morning. And I thank the witnesses very much for their written submissions, which are, as always, available to the public on the committee's web pages. And I invite Stephen and Bobby to make a short opening remark if they would like to. Stephen Bogle, perhaps I can turn to you first.
Yes, good morning. Thank you very much for inviting me to give evidence. I think just generally I would say in favour of this bill. I think it's important that areas of private law in Scotland are periodically reviewed by the Law Commission and particularly Parliament, and particularly defamation needs to have regular review. And so in general this is a welcomed bill, and I think it does improve accessibility to the law, so it's a good thing. However, there are some caveats. One of them, I think, is that we have exaggerated in debate the problems with the existing law. I think there's been a tendency to show or suggest that the common law approach in Scotland is in some way antiquated or out of date and not up to scratch. I think there's been an exaggeration there. That's not to say that this bill isn't important. And the second thing is that I do think there are some tweaks that need to be made to this bill, which collectively, if not addressed, then collectively there would be problems with this bill. But if we were to make some tweaks, then I think we could have something that maybe is not perfect, but would be an improvement.
Okay, that's great. Thank you very much. We're going to run through broadly the same questions as we did with our first panel this morning in broadly the same order, unless I screw it up. So we'll start with Liam MacArthur, please. Liam.
Convener and good morning, panel. Let me start with you again, Dr. Bogle. You will hopefully both of you will have heard the previous evidence session we had with the faculty and with the Law Society. I think it would be fair to say that they're perhaps both somewhat more critical in terms of the tweaks that are required in achieving that balance between protection of freedom of expression and protection of the right to privacy. So I would just be interested in your views on what the sorts of tweaks are that you think would allow the balance to be properly struck in that respect, and how specifically the meeting of the obligations under ECHR can best be achieved. Dr. Bogle, maybe start with you.
Yeah, I would feel more comfortable to start with the ECHR and to say that the existing law and this bill is compliant with the expectations of the ECHR and the Human Rights Act 1998. So now what we're talking about is a balance, or even, should I say, policy and political decisions about where that balance should be struck. I think that it's clear that collectively the clauses in this bill lead towards a balance more in favour of freedom of speech. And I would just say that that is what the bill is doing. It is moving things more in favour of freedom of speech. Whether that's a good thing or a bad thing is a political decision as much as anything else, because from a legal point of view, there's no problem and there's no concern from the ECHR point of view. I don't know, was there a second question, Liam?
I mean, it really was around that. I know we've scheduled the evidence sessions in terms of getting the perspective, obviously last week, of those who come from this issue with from a media perspective and a publications perspective this week, while obviously the faculty and the Law Society will find themselves on both sides of the argument. I think we've exposed some of the apprehensions about that rebalancing, and so I think it's understanding if the political drive is in relation to rebalancing it in favour of freedom of expression, what the implications, I suppose, are for the right to privacy. I mean, you've made clear that there isn't necessarily an ECHR concern, but obviously we've heard concerns in the previous session about the implications for those who feel they've been defamed and wish to exercise their rights in that respect.
Yeah, so I think that if it is moving more in favour of freedom of speech, then there are particular things that we need to be mindful of, and we will come on to speak about serious harm threshold, and I don't want to go into that there, but I do have some comments about the serious harm threshold in the sense of saying we need to be mindful of the fact that it may not be doing what we think it's doing, or at least the debate is framed it as a very significant and important protection for freedom of speech, and I'm not entirely sure it will do that in practice.
We're going to come on to that in a second. I just wondered, Dr. Lindsay, is there anything you want to add to what Dr. Bogle has said?
Good morning. No, I'd just like to point out that even prior to the 2013 Act in English law, the English law of defamation, which to our present intents and purposes on these broad balancing questions is very similar to Scots law, has been taken to the Strasbourg court a number of times. And except on the issue of the provision of civil legal aid, I think the Strasbourg court has broadly held that the balance as struck even before the reforms similar to that under consideration today has been struck perfectly, or at least within the state's margin of appreciation. So I've got no real concerns about the balance as struck presently.
It was described, I think, by Duncan Hamilton from the faculty as perhaps an English solution for an English problem. Is that something that you would recognise? Do you see that as something we're at risk of seeking to do through this bill?
Yeah, absolutely. It follows the Defamation Act 2013 quite closely, and even in provisions or in areas where there is a good case for Scotland doing something different, which the previous panel made that point quite well. The decision has been, it seems, from the early days of the Scottish Law Commission's consideration to tack quite closely to the English approach. But that's certainly something that we recognise.
That's very helpful. I think we'll get into the detail of some of the stuff that Dr. Bogle, I think, was hinting at as well there. So that's all from me, Convener. Thanks.
Well, thank you very much, Liam. Could I turn then to the definition of defamation, which is offered in the bill, and ask Bobby Lindsay first whether you have any concerns about the definition that's offered, and indeed whether you think that the bill is right to offer a definition of defamation.
As the earlier panel stated, the definition of defamation is not really a difficult one. If you type it into Google, you get a very good definition from the authoritative case. So in that sense, I don't see any particular concerns about accessibility. The real difficult question, which a statute cannot answer, are questions like, how does this definition apply to a particular statement? Is the statement one of fact or opinion? So there's always going to be a difficulty in answering those questions that a statutorily ensconced definition is not going to help. I think we do have some concerns about the way that the definition in particular is framed in the bill, and I think it perhaps shows that this was not part of the Scottish Law Commission's consultation exercise. One of the concerns that we flagged has to do with the use of the term ordinary person. I'll leave that to Dr. Bogle to go into. I'll focus, I think, on perhaps some more technical points. The first I'd like to focus on is the requirement that the statement be about a person. Now, that, in our mind, is changing the present law, because the present law requires that the reasonable reader of the statement would take it to identify or to refer to the subject of the statement. And that's an objective test. About a person, we think, is a bit more subjective and looser than the test which presently operates in well-established case law. And it may be that in adopting that formulation, the bill is unwittingly widening the scope of statements which might be actionable. I have in mind here, for instance, the phenomenon of subtweeting, where somebody will say something about someone but not specifically identify who it is about. Now, under the present law, a reasonable reader of a subtweet will probably not be able to tell who it is about. But if the law simply states that the tweet has to be about a person, the communication has to be about a person, then there is an argument that those sorts of situations would be potentially actionable if the potential pursuer were to find out that they were the target of the defamatory remarks. The other technical point I'd like to make is the use of the term publication throughout the Act is slightly strange. In defamation, we tend to use the term communication, and we know that quite well. And communication brings to mind the idea that it's not about putting something down in hard copy that's made available to the public. It's simply about making something known to, as the law stands at present, at least one other person. And we're not quite clear why the bill goes to the hassle of using the term publication, but then defining it as communication. It also raises potential issues with the limitation provisions in Clause 32, Paragraph 1, Part 3. So those are two technical objections we have. I think you're about to hear perhaps a more substantive objection to do with the use of ordinary and the lack of an evaluative criteria beyond that.
Thank you. Stephen, do you want to pick up that gauntlet that's been thrown down for you?
Yes. So in some ways we're trying to codify a very familiar definition, not just in Scotland, but in England, Wales, and common law jurisdictions more generally. But what has happened is in the bill, we see this definition of the ordinary person. That is who the bill at present says we need to consider. So if a court is asked, has the reputation of this person been affected? We need to ask, has it been affected in the mind of an ordinary person? Now, that's what the bill says. Now, that's not a familiar definition in England and Wales, nor in the present law, because the present law has a really important qualifier, reasonable. So in England and Wales, confirmed by the Supreme Court in 2019, in the Stoker against Stoker cases, ordinary reasonable reader. And I think it's important that we don't wander too far or do anything, particularly when we're doing something that would otherwise be a tricky task for a drafter, but nonetheless a straightforward one, is putting the definition of defamation down. I think we need to just put in the qualifier of reasonable, because it means that the judge doesn't need to be, well, these are what opinion polls say or such like. The qualifier also helps the court to maybe sometimes rise above the transient opinions of people at any one time and think about, in a progressive society, what does the reasonable person think? So I think we need that there. It's a tweak, and I think it's been inadvertently missed. And I think, though, the effect of it could be quite significant if it's not just placed in there.
Okay, that's very helpful. Thanks. We're going to move to the eminently reasonable person now, Rona Mackay. Rona.
Thank you, Convener. Dr. Bovill, can I come to you first and bring you back to the issue of serious harm and the serious harm threshold? I think it's fair to say that the previous panel were vehemently opposed to it. Can I have your views on it, please, and expand a bit on your thoughts?
So I can understand what the Scottish Law Commission wanted to do with this. I can understand what the Scottish Government's trying to do. I understand Scottish Pen's position, but in reality, I don't think it's going to address the mischief that everyone has mentioned. And I think there's a lot of concern. Well, it's taken from the English provisions, and as we've heard, that was really about addressing a problem they had in England and Wales. They still have a huge amount of defamation litigation for various reasons, and it was a means by which in England and Wales they'd hoped that they could maybe stop some sort of libel tourism, as they call it, but also ensure that it was only the most important cases came before the court. And I think Bobby might add to this, because there are some statistics that might tell us that it's not actually done the trick in England and Wales. But the problem is that if you think your reputation's been harmed, you have the resources and you have the stomach to actually raise proceedings against someone, or to initiate action, or even to initiate pre-litigation correspondence, then you're going to do that. You are going to think that your reputation's been seriously harmed. And I just don't understand and particularly also the idea is that really you need to, first of all, in a court case, establish first that the statement was defamatory, and then as the process goes, you then need to show that it was seriously harmed in England and Wales. So we're not, in some sense, getting rid of all the problems that have been identified in the mischief of pre-litigation correspondence having some sort of chilling effect. So it may not be that effective.
Can I just, on that point of the pre-litigation letters, you called it a mischief. Is it something that you, well, A, think is a problem, and B, would the serious harm threshold affect that the amount of letters, which clearly are just a threat, they're not going anywhere?
So through the whole process of talking about the reform of law of defamation, I've learned quite a lot from the consultations that the Scottish Law Commission have done and the various events. Definitely seems that we do have a problem that I don't think is exclusive to Scotland, is that as far as I understand it, the media industry may not always have the resources to defend actions or the ability to have legal advice. Maybe the Times does to report on issues in Scotland, but maybe some of the media based in Scotland can't do that. But I don't think that the serious harm threshold is going to stop this from happening. In some ways also, if you're going on a bear hunt, you might expect to find a bear who's going to come after you. So there's going to be litigation, or at least pre-litigation correspondence. I don't know much way around that, unfortunately.
Yeah. Because I got the impression that, in discussing it and with last week's panel, it was almost a practice that was expected, and I suppose it sort of devalued, the letters that came in so frequently didn't have much meaning because they were almost expected. It was part of the process, and I just wondered what you thought of that. But you've just said that you don't think the serious harm threshold would really affect that practice at all.
No, the limitation changes may actually focus people's minds and get these issues sorted out quicker rather than later.
We'll come on to that later. Can I ask Dr. Lindsay for your views, please, on just the questions I've been asking Dr. Bogle?
Absolutely, I completely agree. It's described as a serious harm threshold, which suggests that it's quite an impressionistic binary question that can be answered at a glance. But the experience from England and Wales has been that it's actually quite a multifactorial and quite an intensive inquiry. And the evidence from England so far, scant as it is that if its purpose was to curb the number of defamation actions proceeding before the English courts, it has manifestly not fulfilled that purpose. 2019 had the highest level of defamation claims issued in England and Wales for quite some time. There were 132 claims initiated in 2013, the year before the provisions of the 2013 Act came into force, and in 2019 there were 323, so that's almost 200 more claims. And in the cases which deal with that threshold, especially after the Supreme Court's consideration of the test, you get a sense from the judges that this is actually quite a resource-intensive question. It's not something that can be answered right away. It's not something that can be answered simply by looking at the written statements. You need to hear the evidence, and you need to also first work out what the statement means. So even though the fact this is a threshold makes it seem like this is the first hurdle, actually, before you answer that hurdle, you need to first work out what the statement actually means. And that's never usually something that the parties to a defamation claim will agree upon. Now, the fact that it adds cost to litigation might act as a disincentive to litigate, but it does mean that where you do have a claim which is arguably going to get over that threshold, there is no doubt that such a test will increase the burden and the cost of litigation, which in a defamation claim already is severely high.
Yeah. Thank you. That's really useful. Thank you.
Thank you very much. Liam Kerr has a brief supplementary, and then after Liam, it will be John Finney. But Liam first, please.
Thank you, Convener. I will be very brief. I just, on a point of clarification, and I genuinely don't know the answer. I've never practiced in this area at all. Panel, do you know, when Rona Mackay was asking about letters before action, effectively, do you know whether there is a pre-action protocol in place in Scotland in actions for defamation, which would mandate the sending of such a letter prior to taking any action?
I would have to defer to my colleague, Dr. Vogel, as he is the only one with a practicing certificate here. But I think a more general point might be that the whole nature of defamation law procedure in England and Wales is far more developed than it is here, and that might be an aspect of it, but I can't comment on that specific point.
So my practicing certificate expired a while ago, so the actual ins and outs of the procedure, and I wouldn't want to make a comment on that. And so it's a pity that we didn't have Duncan here, who could probably have answered that quite quickly for us. But it's inevitable, even before you raise an action, that there probably will be some sort of correspondence between parties. And the thing is that people always interpret lawyers' letters very seriously, but then when you actually know a bit of law, you just realise it's often about strategic positioning, and people may not be serious about going to court or not, but it's difficult for people sometimes to decode that. But I don't know the direct answer to your question, I'm afraid.
Thank you for that. I think you're right, Dr. Vogel, just in your summary of the kind of general practice and where you would send a letter and why that correspondence is taking place. Convener, it is my understanding, and I stress this is not my practice area at all, but I believe there's a pre-action protocol in England, and I wonder if after this session we might perhaps just write to the previous panel, for example, and just establish whether there's a similar pre-action protocol in Scotland.
Thanks. I'm not going to answer that question now, but what I am going to do is turn to John Finney. He's been very patient. John.
Convener, and good morning, Dr. Vogel and Dr. Lindsay, and thanks for your written submissions. I know you've listened in the previous session, but nonetheless, for others who may be watching who haven't heard, I'm going to ask again about the Derbyshire principle, which is the principle that prevents public bodies from suing for defamation. That's replicated in this bill, and the issues that have come as a result of that relate to the fact that we nowadays have many different models of delivering public services, and understand that people want to have public scrutiny of those. There is an exemption for business and charities who deliver services, quote, from time to time. Now, with a lot of aspects in the bill, we've had differing positions from generally media correspondents or legal representatives. So the media people are concerned this would prevent effective scrutiny, lead to a postcode lottery, and indeed fundamentally undermines the Derbyshire principle, whereas you will have heard from legal representatives that they feel that the effects of Section 2 are not clear, drawn much wider than previously, and the implications for housing associations, universities, and indeed for individuals delivering public service, such as doctors and nurses, preventing them from raising actions. Now, several legal representatives suggested alternative models to drafting, essentially focusing on bodies that are definitively covered, so central government, local government, and your submissions, Dr. Vogel and Dr. Lindsay, suggest adding an indicative or definitive list for clarity. Now, Sometimes it's felt definitive lists, of course, can be problematic. I wonder, can you comment on this particular aspect of Derbyshire and how you would see as perhaps a way of addressing them, please?
Sorry, Stephen, you can go first.
I should have directed it to one of you. My apologies to broadcasting too.
Bobby was probably going to tell me to answer it anyway. So I think this is a very, very difficult question in terms of how you actually draft this. My instinct would be that more guidance from Parliament and in the bill is needed, or better drafting, dare I say. Drafting is not an easy thing, but I think there needs to be some attention to it, particularly as you highlight there, the time to time feels very loose and uncertain. My solution would be under Clause 2, subsection 8, it mentions regulations. And I think maybe that may be the place that some more specificity could be added. And I think an indicative list would be helpful. This is a decision that I do think should be made by the legislator rather than it being handed over, kind of almost like if the law is like the analogue, it's been digitised, and then handing back the digitised version to the courts is tricky. I think my suggestion would be some more clarity from the government as to actually who they want in terms of the bill that they are sponsoring, who they want this particular section to capture.
Thank you very much. Dr. Lindsay, do you have a view on that, and particularly on the question of a list and problems that might be created by having a definitive list, for instance, please?
Yes, well, first on the question of the Derbyshire principle as a whole, I think it's important to remember that this is not a defence. This is an absolute prohibition on stipulated bodies being unable to sue. And I think the issue with extending it into private public service providers is that it really is a question of degree. I think we're all agreed that local authority and central government should not have the power to sue in defamation, and that's the justification on which the Derbyshire principle was founded. When you get to private companies who provide a public service, though, the first thing I would say is that, well, if you allow them to sue, there's usually going to be a very good argument under what is now clause 6 of the bill, that there's a defence in relation to publication in the public interest. There's also an issue that these companies enjoy human rights, and it might be that if a private company is excluded from suing in defamation, they could launch a challenge to that under the provisions of the Scotland Act. I think the more proportionate measure might be to say it's simply about local and central government, and when it comes to your private companies providing a public service, that the Clause 6 defence might do much of the lifting there. On the topic of the stipulated list, it certainly should not be an exclusive list or an exhaustive list, but I think certainly concerns have been raised about things like schools and universities. I think that if a list were to expressly stipulate these are bodies which are not subject to the Derbyshire or the Clause 3 prohibition on suing, I think that might be quite helpful, but it by no means should be an exhaustive list.
Thank you. If I may, Convener, very briefly, can you comment then, Dr. Lindsay, on the fact that some of these services that are delivered by multinational corporations, often on lengthy contracts, and the relationship between that and, if you like, the electoral cycle, if that's intended to be a way of scrutinising, it would seem that there shouldn't be areas of public life where public scrutiny, you would argue in some respects that if you can't hold the individuals responsible at the ballot box, then the part of the public service that's delivered by the private company should be open to more scrutiny and less challenge.
I think maybe the counter to that, though, is that the initial decision to delegate those functions in the first place is, itself challengeable at the ballot box. But again, I think in terms of framing the definition, I think the more narrow a definition of public authority that you have, the more you're going to be able to have these things ventilated in the courtroom, which for things like this, maybe are a more effective means, especially with a multinational corporation, of them trying to clear their reputation than a local authority council meeting. But I certainly do take the point.
Okay, many thanks indeed. Thank you, Convener.
Okay, thank you very much. I'm going to bring Annabel Ewing in next, and then after Annabel, Liam MacArthur has a brief supplementary on this. But Annabel first, please.
Thank you, Convener, and good morning, gentlemen. On the wider issue of eligibility in general, it had been suggested, I believe, at last week's committee meeting by PEN and also in correspondence from media respondents that eligibility should be restricted as far as businesses are concerned to those with fewer than 10 employees. I understand this is motivated by a desire to see equality of arms. It would be helpful if you could provide your thoughts on that in terms both of the issue as a matter of principle and in terms of the particular threshold being discussed. Perhaps I could go to you first, Professor Bogle, and then Professor Lindsay. Thank you.
Thank you. So, in principle, I would say that actually companies shouldn't be able to sue in defamation whatsoever because they are not natural persons. Companies benefit from a whole other different characterisation of their legal personality. However, that would be a very innovative change to introduce. But in principle, I think companies should be, our corporation should be able to follow the part, I think it's part 2, the malicious publication. They are tailored and made for businesses and companies to protect their assets and their property and their interests. But that's in principle. I think that would be it'd be quite innovative for Scotland to do this, and I think it would be quite late to introduce something like this to the bill. So for pragmatic reasons, I think it's not the best time to do it. And I think unless there was going to be a significant review of the policy behind this, then I don't think we can do it at present. Although in principle, I'd be interested in doing something like that.
Thank you for that. I mean, when you talk about companies, do you mean simply then limited companies as not being natural persons, as opposed to other business structures that may not involve incorporation?
Yeah, so it would be organisations that benefited from limited liability. If you provide that limited liability, you're characterising them completely different in terms of their legal persona.
Okay, thank you for that clarification. Dr. Lindsay?
This is one of the few points on which Dr. Bogle and I disagree slightly. I think that in principle, there is a good argument for saying that companies have a right to reputation. And you may have heard of the McLibel case, the defamation case that ran between McDonald's and two English people in the 90s. That got taken to the European Court of Human Rights, and the European Court of Human Rights made the point that actually sometimes it is important for large multinational corporations to have the right to defend itself, and the means by which a legal system provides that is within a margin of appreciation. And I think that's my point of principle. My point of practice would be I think it's very easy for a director of a company or a shareholder of a company to read something that defames the company and make an argument that that is actually defamatory of them in a personal capacity. And that way the sort of restriction on the legal entity being able to sue might be quite easily circumvented. And this is recognised in the Australian model law provisions that some mention has been made of. It's important to note those provisions, although we talk about them as being the Australian position, they're actually only in force at present in New South Wales. And there's been some review as to whether that position should still obtain. We can draw an analogy here also with a related part of the law of delict, which is the delict of harassment. Now, the delict of harassment is not one which is open to a company to litigate for. It's specifically limited to an individual. But we have seen in the case law, private companies and representative bodies have taken action on behalf of their employers or their members in order to sue for that. So I think that in practice there would definitely be a way around that restriction quite easily. So that raises the question, why bother in the first place?
Thank you for that answer and for the clarification that in fact the so-called Australian model is not the Australian model, it's the New South Wales model, and I guess look into further, but thank you very much for that helpful elucidating response. Thank you, Convener.
Thank you very much, Annabel. Liam MacArthur, please.
Thanks, Convener. Just wanted to go back to the line of questioning being pursued by John Finney in relation to the Derbyshire principle. It was suggested, I think, last week that the principle was founded not so much on the nature of the service being provided, either entirely in terms of the public sector or the private or voluntary sector from time to time on behalf of the public sector, but more to do with the fact that the elected nature of local government, national government, meant that there were other remedies. Is that the underlying principle here, and are we in danger of moving away from that through the course of this bill? Dr. Bogle or Dr. Lindsay, I'm not quite sure who's best placed to pick that up.
I certainly would agree that that's the underlying principle, and you are in danger of straying from that by expanding the definition.
That's helpful. Thank you.
Okay, thank you very much. Rona Mackay, please, and then after Rona, it will be James Kelly. Rona.
Thank you, Convener. Yes, I'd like to ask if we can start with Dr. Bogle first, please, to go back to the issue of secondary publishers. You'll have heard the first panel answer questions around that. Can I ask your views on what's been proposed in the bill, and in particular with regard to the internet, because I think that's a huge issue?
Not as concerned about it as the previous panel, although I suppose I come at a perspective of what's the policy behind the bill and what has the provisions done, and do they match up? And it appears as though in this section it matches up. I mean, the thing is, there's so much defamatory stuff said on social media. It's quite incredible, and to try and solve these sorts of problems with a defamation bill is pretty ambitious. I think these problems are solved at a much larger level than individuals raising actions. That's not to say that individuals shouldn't have the opportunity when it arises, but I think that the provisions that are in the bill at present make sense, and I'm not as concerned about them as the previous panel.
Yeah, because we know that in America, obviously internet providers have complete immunity against defamation, and obviously this is an ongoing area of concern. So you're content with what's been proposed in this regard, that secondary publishers would not be liable?
Yeah, because something does need to be done about this, and that's the Scottish Law Commission. When they looked at this, my response to them was, this is a difficult thing that should be solved at a UK level, if not a European level, and to try and solve it all in this bill, risks us jumping the gun. Now, it's a difficult situation for Parliament right now. Do you go ahead with saying very little about operators and intermediaries, or what do you do? And I think we just go ahead with what we have, and something I'm sure will, hopefully, fingers crossed, come about to solve the problem of intermediaries maybe hosting content. But I think there are existing solutions already, but they're just very cumbersome to solve these problems.
Okay, thank you. Dr. Lindsay, can I have your views, please?
I would agree with everything that Stephen has said there. The complicating factor here is, of course, that the website will always be based in another jurisdiction, and as much as we would love to have these rules apply across the world, foreign courts don't really listen to Scottish court orders on these matters. There's a slight exception there insofar as we're part of the European Union. They might. But that obviously is not going to be the case, sadly, relatively soon.
So what you're saying is there's no real easy solution to the internet problems.
There's no easy solution, and there's also no national solution.
Yeah. Okay. Thank you both.
Thank you very much, Rona. Okay, James Kelly is next, and then after James Kelly, it'll be Liam Kerr, please. James.
Thank you, Convener. Good morning, panel. Just turning to the area of defences, just wondered what your view is on how the defences are codified in the bill. You know, for example, truth, publication, and the public interest and honest opinion. What's your view on that? First of all, Dr. Bogle.
So, in general, the codification is fine for me. The restatement of defences and the updating of them is fine. For me, I have concern about Section 8. So Section 8 is the abolition of common law defences and transitional provisions, and that lists that the existing defences, which the prior provisions are replacing, are abolished. Now that's fine for clarity in terms of the actual doctrine being abolished, but I don't want to throw the baby out with the bathwater, because things like the Reynolds defence and the case law around that is very useful, and we shouldn't be creating the assumption that you shouldn't look at them. And now the explanatory notes do suggest that there should be some consideration of that. But what we've seen in recent litigation in England and Wales is that the courts are saying the Defamation Act 2013, it has introduced a new regime. It's not just a mere cut and paste from the common law, but that you can go back to the existing law that predated the 2013 Act to seek some guidance. And that's the thing that I would want it in the explanatory notes, at least, to make very clear that although these defences are abolished, that does not mean to say that the rich resources of case law that already exist, whether it's in England, Wales or in Scotland or elsewhere, can't be used.
Thank you. Dr. Lindsay, your view?
I would agree with that point. The first point I'd like to make is it's not a complete codification of the defences that are available to a defamation action. There are some which are, for one reason or another, omitted. There's the idea of fair retort. There's the very important general qualified privilege defence. And there's also, beyond Clause 9, no codification of the situations in which a statement would be absolutely privileged. And that's perhaps fine. I think we have a good grasp on what those defences are, and maybe we don't need to codify them. But if we're going to codify these three, it raises the question, why not consider the others? There is one specific point, and this was raised by Professor Reid and Professor Blackie in their evidence, that the qualified privilege provisions in Clause 10 to 11 need to make it clear that the existing general common law qualified privilege doctrine is unaffected by the statute, because it might be possible to read the statute as having abolished that, and that certainly is not the intention of the legislation, nor has been mentioned anywhere or suggested anywhere in the reform process. As for the three defences themselves, truth, I think there's no issue with. The public interest defence, I think I would echo what Dr. Bogle has said. It's really important that specifically the preceding English case law is still something that can be turned to, and the factors can be considered. We heard last week that the 10-part test, which is part of the Reynolds judgment, is quite a useful checklist for journalists. We heard in the last panel some concern about the removal of the public interest qualification in the defence of honest opinion. On this point, I would note that The Inner House recently considered this defence in the case of Campbell against Dugdale, and the opinion of the Lord President doesn't really place it much emphasis on this requirement. So it's unclear what role that requirement continues to play. If that requirement were to be retained, I don't think it's too much of an issue, because it's relatively easy to satisfy that something is in the public interest. The most recent UK Supreme Court case has held that reviews about a wedding band on a website were sufficient to engage the public interest for this test. So that's not really something that I have a strong feeling on, but just to maybe add some colour to the prior remarks. But overall, quite happy with these sections, subject to those modifications.
Okay, thank you. So the current bill is fine in that area. However, there needs to be, proper reference to case law, and they might even have to be added to. Can I turn now just to the area of compensation? You might have heard the discussion with the previous panel around the area of the offer to make amends and discounts being available in terms of compensation. Do you think that that's a principle that needs to be retained in terms of the new legislation? Start with Dr. Lindsay first.
So this pertains to clause 14.5, and I agree with Mr. Hamilton that you can maybe read that in a manner which suggests that the discount is still an option for the court to take into account. However, I think it would aid clarity if it was made specifically clear in clause 14.5. There's another point here that touches on the relationship between the offer to make amends provisions and the clause 19 on jurisdiction. Now, we're coming to jurisdiction later, but perhaps it would make more sense to address this here, and that is that, and this is picked up in the evidence by Campbell Dean, that raising a jurisdiction challenge should not by itself remove the ability to make an offer to make amends, but the reading of clause 13b, 13.2a suggests that it is, and I think that's something that needs to be made clear, that challenging the jurisdiction of the court is not a belligerent act of "I'm not sorry." It's simply working out the proper place for that dispute to be heard. And actually, once the dispute is properly allocated to a particular court, that normally is the stage at which the case will settle. So to say that the opportunity to make amends is clipped at the point of raising a jurisdictional challenge, I think is problematic for the reasons that Campbell Dean has set out very clearly.
Okay, thanks. Dr. Bogle, have you got a view?
So I did think that clause 14, subsection 5, did actually allow the court to take that into consideration when awarding compensation. So that's certainly not how I read the bill. And so maybe that validates the point that Bobby's just made there, that a very simple clarification there under that section or around that particular subsection would be useful, because I didn't think there was a changing of the existing position. I thought that clause allowed the court to take it into consideration.
Okay, thanks. Obviously, that's an area that we'll need to clarify when the government gives evidence. Thank you.
Thank you very much, James. Okay, Liam Kerr next, and then after Liam will be Fulton McGregor, please. Liam.
Thank you, Convener. I shall cut straight to the chase. If the serious harm test panel is to be retained, should it be ported into the area of malicious publication, particularly given that in Section 21 and following, the pursuer doesn't need to show actual financial loss, just that it is likely to. So should serious harm, if retained, be ported into malicious publication?
Absolutely, 100%, yes. The malicious publication delicts that we find in this part of the bill are really quite arcane and archaic. I don't recall seeing them featuring in reported litigation since about 2003, and you certainly don't want to reanimate them and make them a valuable line of attack for a business. I think the risk is that you're always going to have a claim in defamation, which is bundled up with a claim under these delicts, and if a malicious publication claim fails, there'll be defamation as a fallback, and vice versa. My personal preference would be to just abolish them entirely, but there's no real harm if the serious harm threshold is put into there, because as you stated, the current provisions simply make reference to financial loss, not serious financial loss. And I think it would make sense in terms of consistency, if we are going to retain serious harm, that it is part of these provisions also.
Very helpful, thank you. Dr. Bogle, do you have anything to say on that?
Completely agree with Bobby on that. You could sort of interpret the bill as assuming that this would apply in Part 2 of the bill, but I think that we need to have the serious harm threshold in there. If Part 2 is to remain, then it needs to be there.
Thank you. Do either of you take a view? I imagine you saw the panel earlier, and I asked specifically about an interplay between particular sections in 21. Do either of you take a view on whether the inclusion of indifference as to malice, as to harm, as a qualification is a reduction in what we have currently, a lessening of the threshold, if you like? Dr. Bogle, since you're on screen.
I might hand that over to Bobby, because I know that Bobby's got particular opinions on this.
I don't actually have particularly strong opinions of that. I agree with Mr. Hamilton that I think this is merely reflective of the present law. I don't think it's watering it down to any great degree. So I'm quite, if we're going to retain these provisions, I'm quite content with that as presently drafted.
And perhaps then, Convener, if I may ask one more very brief question, specifically to Dr. Lindsay. Do you, given all you've said just now, and more generally, do you have any views about whether the sections on malicious publication have the potential to undermine freedom of expression?
I don't really think so. I think all it does is it offers more option to a potential corporate pursuer. They get one bite at the cherry with defamation, and then they get a second bite at the cherry with the malicious publication proceedings. I think the fact that in a malicious publication action, the pursuer has to prove not only that the statement is false, but also that the statement was intentionally made to harm. I think that's enough of a control mechanism. And we've seen the law of defamation sometimes criticised because it shifts the burden on those two regards to, in the case of truth, to the defender, and in the case of malice, well, malice is, in most cases, irrebuttably assumed. So I think in terms of freedom of expression, that those two control mechanisms perhaps is sufficient. I think my concern is more sort of one of legal horticulture. I don't think these provisions are particularly tidy, and I don't think they're particularly necessary if we're retaining defamation in its current capacity to apply to profit-making bodies.
Thank you.
Excellent. Thank you very much. Legal horticulture is a new one on me. I'm not quite sure who's on gardening leave here, but Fulton McGregor next, please, and then after Fulton it'll be Shona Robson. Fulton.
Thank you very much, Convener. I want to go back to the same line of questioning from the previous panel around Section 30 of the bill and around some of the concerns that we've heard about this particular section. As you'll know, it allows the court to order a third party to remove contentious material as an interim measure before a final decision regarding whether it's defamatory nature or not has been reached. Do you have any concerns about Section 30? And if so, have you got any possible alternatives? And if I could, Lindsay.
So I don't have any real concerns with Clause 30 at the moment. I think it might be might perhaps be useful to cross-refer to Section 12 of the Human Rights Act 1998 here, which basically says that if you are trying to get an interim remedy, a remedy that's awarded before the dispute is definitively concluded, that particularly keen attention needs to be paid to the importance of freedom of expression. I think the only other point I would make is that, as I've said before, the Scottish Court can try as it might and make an order for a website set up on a server in Panama to take down a defamatory blog post, but the reaction to that is not going to be very welcome, or it's not going to be entertained in the foreign court. So I think there are, sadly, as was said with secondary publishing, there's a limit to what a national solution here can achieve.
Okay, thank you.
So I don't have any concerns about Section 30 or Clause 30. I think it's particularly important that we retain the existing powers that the courts will have. The court session very recently did make an interim order of specific implement for the removal of material. And I think, as Bobby said, that the existing law is able to comply with ECHR requirements, and I think the court session showed that what it already has is sufficient, but there's no harm in having Section 30 or Clause 30, I should say, there.
Okay, thanks for that. I'm happy with that, Convener. Thank you.
Thank you very much, Fulton. And Shona Robertson next, please. Shona.
Thank you, Convener. You might have heard or read the evidence from Scottish Pen last week, which has put forward proposals for a new court action to provide protection from unjustified threats of defamation action. First of all, do you have any views on this, and in particular how it might operate in practice? Maybe Dr. Bogle first.
Yeah, so as I said earlier, if you're going to go on a bear hunt, you're going to find a bear and you're going to get into trouble. I just don't know how introducing some sort of counter measure would help, because in fact it would get you tied up in some human rights concerns about access to the court, and it would be pretty novel also. I know that it exists within intellectual property, but it's a different context. I think the problem would be you wouldn't quite know where to draw the line if you introduced this, because do you introduce it to contractual disputes? Do you introduce it to negligence disputes? At what point do we draw the line and say, no, it's just in defamation? We want people to play nicely, and we're going to have a counter action for a defender. So I don't think that this would be a good idea, unfortunately. I have to disagree with quite strongly on that one.
Okay, Dr. Lindsay?
I think it's certainly an interesting proposal, but I think it would need much more discussion and thought before it could go onto the statute book. Stephen's quite right that the model for this, the 2017 Act, it is a very different context. It applies to registered intellectual property rights that you can go to a register and look up and find out the extent of. Defamation is not that clear, unfortunately, and this bill won't do enough to make it that crystalline. I think it's important to note that there already is some protection in the law in the form of the delict of harassment, which I've mentioned earlier. If you repeatedly make unjustified threats of legal action that causes alarm and distress to somebody, then there has been case law which has held that an action can be brought in harassment to claim for damages or a non-harassment order. Now, that's only going to cover extreme cases, but perhaps it's only the extreme cases that we need to worry about. I think what this proposal perhaps is emblematic of is that civil procedure in Scotland, as we've already heard, is not as sophisticated as it could be compared to England and Wales. In England and Wales, if you get a defamation letter through and the claim form is served, you can make a motion to have that struck out of the English courts, and that's not a power that the Court of Session obviously has on the face of the rules of court. And I think this was mentioned in the context of the civil justice reforms, but a device like that might be a more useful mechanism than creating a new delict, which we're not really sure about the parameters of which.
Thank you.
That's been very helpful. Thank you very much. As I've been listening to your evidence, two questions have sort of nagged away in the back of my mind, and I want to pose both of them to you now, if I may. You may not be able to answer them right now, in which case please feel free to say that and to write back to the committee before we report later on in the autumn. The first is something that actually Bobby Lindsay raised a few minutes ago, which is Section 12 of the Human Rights Act. Section 12 of the Human Rights Act is designed, I think, to show that, yes, it's true that Articles 8 and 10 are both qualified rights, but some qualified rights are more important than others, and freedom of speech is a very important qualified right, in particular when compared with Article 8 on privacy. We've heard from many witnesses now that this bill shifts the balance a little. Some witnesses say it shifts the balance a lot in favour of freedom of speech and away from protection of privacy and reputation. Section 12 of the Human Rights Act was already designed to do that. So my first question to you is, has it made any material difference in practice in the 20 years that it's been in force? Have the courts paid particular credence to Section 12? Has it made any material difference in defamation cases either in England and Wales or in Scotland? Bobby Lindsay, have you got any information you could share with us on that question?
I think Dr. Bogle will perhaps be able to talk more fully about the recent court session case, which considered Section 12, but there are signs that the courts are taking this into account, especially when it comes to issuing a remedy before the final resolution of the claim. There are real signs that is being followed quite closely and quite carefully.
Stephen?
So yeah, the Court of Session obviously pays attention to Section 12, and it's difficult because we don't have a lot of case law in Scotland on defamation, and particularly on these procedural requests of the court to make an interim order. We don't always get these reported, but it seems as though it's quite straightforward for the court, and in fact, even on the existing law, paying without Section 12, I think the always take into consideration the importance of freedom of speech, and that really should, on the balance of convenience, be what the court pays more attention to. So yeah, I think it does difference. Yeah.
Okay, that's helpful. And the final question I just wondered if you could very briefly reflect on is this. Everybody seems to think that this bill is a good idea, and everybody seems to think that this bill is a good idea in part, and in large part, because it codifies in the single statute most of the core elements of our law of defamation. But I just wonder, is there a risk in codifying defamation, in the sense that the single biggest change to the law of defamation made in the last 20 years was made not by statute but by the courts, and the creation of the Reynolds defence in the case of that name, now enshrined in Section 6 of this bill. Is there a risk that by codifying in legislation our law of defamation, we will inhibit the courts from making future such progressive changes to the law of defamation when the public interest requires it? And if so, is that a risk that you think we should take? Do the benefits of codification outweigh the costs, or is it something that we should be aware of? Is it something we should even put explicitly on the face of the bill, that nothing in this bill is designed to inhibit the future development of the law of defamation by the courts in appropriate cases, or is that not the sort of thing we would describe as elegant drafting? Stephen first and then Bobby.
So I think this touches on Section 8 and maybe even making it clear in the explanatory notes what the intention is, because I think defences is the most important thing here. And I think we need to make sure, in my opinion, I think the courts can continue to develop the law. The problem is we don't have a lot of case law in Scotland. And in fact, legally, yeah, fine, you don't pass this bill, but then I think there's a lot more to be considered in terms of the policy behind it, the public perception, and how symbolically it's important that Scotland makes clear that it's now put on statute the law of defamation. But legally, yeah, I think courts can develop it. I don't distrust judges. Sometimes people distrust judges and want Parliament to do all the work. I don't mind judges doing the work, but I think it is important for policy reasons and other things that we actually do get something down.
Thank you very much. Bobby, anything to add?
I would completely agree with that. Insofar as the bill will create a framework for defamation law, I don't see it as a particularly stultifying or ossifying framework. I think there are certain provisions that could make the relationship with the existing law a bit clearer. Clause 8 is certainly one of them. The offer of amends proceeding is another, and so on and so forth. But on the whole, I don't see this as this is very much a ceiling, not a floor. No, sorry, a floor, not a ceiling.
Excellent. That's really helpful. Thank you, both of you, very much. You've been very generous with your time. This brings the public part of our meeting today to a close. Our next meeting will be a week today, on Tuesday, the 8th of September, when we will continue to take evidence at stage 1 on the Defamation and Malicious Publications Bill. I now close the public part of this meeting, and for those members who are able to continue to join us, we'll move into private. Thank you very much.